Welcome to Missouri Law Matters, a podcast all about your Missouri court system. I'm your host, Matt Hamner. I'm a judge on the Southern District Court of Appeals in Springfield, Missouri. Thank you for being here today, and we don't want you to forget to like and subscribe to our podcast, all the various places that you may find us on Apple, on Spotify. And if you want video to go along with your audio, you can follow us on YouTube and all the other places that you would find those videos and audios. In addition to your likes and subscribes, don't forget to leave us a comment. I'm very excited about our episode today. Family courts in Missouri are one of the most common ways that folks interact with our legal system in Missouri. Odds are that if you have to go to court at some point in your life, it will most likely be related to something concerning family law. Family law can encompass numerous areas of including divorces, child custody proceedings, child support, paternity actions, and many other related matters. To talk to me about these varied and important proceedings today, I have an outstanding guest that I cannot wait to talk to. Joining me today on our episode is the Honorable Sherrill Roberts. Commissioner Roberts is currently a family court commissioner in the 7th Judicial Circuit up in Clay County, Missouri. Commissioner Roberts, welcome to the pod today.
Well, thank you so much for having me. I'm very excited about this opportunity to speak with folks about family court and what we do and trends we're seeing and how folks can best interact with the courts in that capacity.
That's excellent. And those are all the things I want to talk to you about. It's like you've taken my outline and you just summarized it in 2 sentences. That was great. This is going to go very well. I can tell already. Now, Commissioner Roberts, you are the first commissioner that I have had on our podcast. Now, I having been a judge for a while now, I know what a commissioner is, but explain to our listeners and those folks who may not be familiar with it, what does a commissioner, a family law commissioner do?
Sure. Well, not all counties or circuits have a family court commissioner. We're fortunate here in the 7th Judicial Circuit to have a family court commissioner position. And what that is instead of being a judge who is either elected by the people of the circuit or the county or being appointed by the governor, as it is in some circumstances, a family court commissioner is appointed by the other judges in the circuit. So, for example, when this position came open, I, along with many of my other attorney colleagues, applied for the position with the court. And of course, we had interviews, and then the court itself determined who would be appointed as the family court commissioner. So I'm appointed for 4-year terms, which are renewable every 4 years if I'm doing okay. They renew the appointment, and we are appointed to handle specifically family court matters, many of which you mentioned at the open. Divorces, paternity, child support, that is the extent of our jurisdiction. Is we're not doing criminal jury trials for murder cases. We're not doing written possession cases. We're not doing adult guardianship and conservatorships. We're just sticking to the family law matters. I think part of that is so that we can have a modicum of expertise in that area and so that people can feel confident that that's all we do. And we hope that we know what we're doing at some point in those cases then. And the one difference between a commissioner and a judge is when I sign a judgment, it's called findings and recommendations for judgment. So really what it is I'm signing those findings and recommendations. If one of the parties is dissatisfied with the result, or particularly if they think I have made a mistake in the facts or in the law in the trial, they can ask a circuit judge to review that and determine whether or not maybe the circuit judge should hear the case instead. So there's a 2-week waiting period from when I sign my findings and recommendations to when the circuit judge signs off on the judgment, in which time the parties can request what's called a rehearing, which means we think the commissioner screwed up. We want a circuit judge to actually, because we're not Article 3 judges, so to speak, it has to be signed off on by an Article 3 judge so that it becomes final. So that's what a commissioner does and how it's different than a judge.
That's the great thing about this format is you cannot tell me too much. I love the answer, and I think that is an excellent explanation of how commissioners in those counties that we have them can assist the process. You know, it's another set of hands and another set of eyes that can help take these cases that we all know how important they are and they deserve a lot of time. But sometimes in your bigger circuits where you have so much criminal and you have so much civil litigation, sometimes you don't have the time as a circuit judge or an associate circuit judge to devote to these family type law cases. Commissioners are a wonderful tool and a wonderful resource for it. I'm so grateful that you're in that position and that you're with us today. Now, I note that you were first appointed in Clay County as a commissioner back in 2005. You get reappointed every 4 years. And I know that you've been on the front line handling family law cases in Clay County now for 20 years. And I know that in addition to the work that you do as a family court commissioner, which we're going to talk about, you also spend a lot of time teaching lawyers and other judges about family law issues. Talk to me about that experience a little bit and what joy you get out of. I will be quite honest with the listeners today. The very first family law lecture I ever got was from you at my new judge orientation all the way back in 2015.
My goodness. Yeah.
You could almost say that everything I know about family law started with you.
Well, yes, that's something that I started doing. I'm done now, gosh, I don't know, 15 years, probably at least. I was fortunate enough to be appointed to the Trial Judge Education Committee early in my career. And that has really been important to me. It's a committee, just for those who don't know, a Court of Appeals judges, trial judges, and commissioner who prepare the educational curriculum each year for judges and commissioners who are required to attend a certain number of hours in continuing legal education. So got part of that committee, got to be part of creating the curriculum for those, we call them judicial colleges. And then I was asked then to take over teaching the family law component from Judge Thomas Frawley, who had been doing it for many, many, many years and was just a legend. So let me tell you, those were some really big shoes to fill, and I still have not filled them, but I've done my best. And of course, now I'm able to co-teach with Judge Ellen Levy, who's from the St. Louis area. And so we really, really enjoy being able to interact with new judges, as you mentioned, at the new judge education school that we teach at for the family law curriculum, and then at judicial college twice a year to give the family law update. So just we're letting judges know about all the new cases that have come down from the Court of Appeals in Missouri that involve family law, so that all the judges will know the latest status of the case law, as well as the new statutes that come down from time to time from the legislature, because those are things we all need to know when we're on our everyday practice. So it's just really been satisfying, and I enjoy that aspect as well. It gets me out of the courtroom. It gets me interacting with my peers, and it's fascinating for when we're teaching on breaks. Judges will come up and ask us about really unique factual circumstances that they have and ask for our advice, which we do the best we can. It's fascinating to hear the different types of things that are coming up across the state, because you think about it, a law might have been passed 50 years ago, but we're still figuring out sometimes how to apply that law to these new factual circumstances that come down. And I think that's what makes the law so fascinating. And that's one of the things that got me interested in the law in the first place, which is it's never the same. Every day is different. And we're learning every single day we come to work, because we're going to come up with a factual circumstance in a family that we haven't dealt with before. And we're going to have to figure out how best to deal with it under the law.
That's a wonderful way to put it. And it's a perfect transition to kind of my next question. You talk about one of the things that drew you to the law. I always like to talk with our guests and to give people who are listening at home or watching at home some insight into how my guests kind of found their path to the law and then ultimately found their path to the bench and being a judge or a commissioner. So talk to me a little bit about, how did you get interested in the law? What was it that led you into the practice of law?
Well, that's a great question. As long as I can remember, this is what I wanted to do. So I just thank my lucky stars every day I come into this place, because ever since I can remember being a kid, I wanted to be in the law. And ultimately, I wanted to be a judge, or commissioners didn't even exist at that time. And so I went to college, I went to law school, and I was fortunate enough to be hired on at a very small firm. The law partners there were just excellent mentors to me. They instilled in me a sense of real confidence that I could do things, and just guided me as to how to interact with court personnel, how to interact with your clients, how to interact with other attorneys, how to interact with the judiciary. And I was just so fortunate to have that opportunity. And of course, when I came out of law school, I thought I was going to be, like some big time constitutional lawyer or something, right? Protecting everyone's First Amendment rights, Second Amendment rights, right? Well, it didn't really work out that way, but it's a good thing for me that it didn't, because, when you go into a small firm, you do what they tell you to do, right? You do what they need done.
Anything
and so at
that
that
walks
point,
in the door. Yeah.
Exactly. You've got to keep the lights on. You got to keep
Yep.
paper in the copier, right? So you've got to do traffic tickets. You've got to do whatever it takes to, keep that office going. So I was the designated family law person at that time. And so some of the other partners have been doing that for some time, but they were, easing out of that, didn't want to do that anymore. And so that's what I stepped into. And again, I had an excellent mentor who took me along with him to court appearances, let me sit in on depositions and do those types of things. And I never in a million years would have dreamed it, but for some reason, I had an aptitude for it. And it really interested me. And I felt like I could be productive in helping people solve their family law issues. And so I acted as a guardian ad litem in a lot of cases. That really helped me learn the law, meet other lawyers, observe different ways of lawyering in family law so that I could kind of emulate what I thought was good, maybe not what I thought wasn't so good. And so I did that for 13 years, which I loved. But when the opportunity to apply for the commissioner position opened up, I did apply. And I was, again, fortunate enough to be selected. Like I say, the rest is history here. I've been here ever since. It really taught me it is so important to have mentors in the legal profession. I just see sometimes young attorneys who come out and who seem to struggle the most are those that have just hung out their shingle. And I get that. I admire the courage that it would take to do that and the ambition. But even if you do that, I try to encourage them to find someone in their community that they can also, hey, you know what, pick up the phone or email them and just say, hey, here's what I've got going on. How would you approach this? Or how would you suggest that I approach this? Because I just think having mentors as a young attorney is so, so important.
It absolutely is. We've had several guests on the pod over the last few months who have communicated the same thing, the importance of mentorship and praising the mentors they have and encouraging young lawyers, people that are interested in the law, to seek that mentorship out. The legal profession is kind of one of those odd ducks, and that you can't learn everything that you need to know about being a lawyer from a book or from watching YouTube videos or
Right.
even from your schooling. There's
Absolutely right.
There's a certain part of becoming a lawyer that you can't really learn except from somebody else who's already been there, who's experienced it and kind of been in the trenches. And so I love that you're so passionate about mentorship. That's a wonderful thing for our profession, and certainly a wonderful message for all the folks at home too. You mentioned that you spent so many years, in private practice handling family law cases, and now you've switched over, and for the last 20 years, you've been a commissioner handling family law cases. Is there anything that you miss about being a private practitioner handling family law cases versus being a commissioner? How different is it for you?
I'll tell you what, one thing that I do miss is the camaraderie that I had with my fellow attorneys. When you're waiting for your case to be called and you're hanging around out in the lobby of the courthouse or getting coffee, I really, really enjoyed talking with my peers and running scenarios by them. And what do you think about this? And I really miss that because, of course, as part of the judiciary, it's intentional that we are slightly separated from practicing attorneys. Obviously, we still have friendships. Obviously, we still have networking opportunities with working lawyers, but you have to separate yourself a little bit because you want the public to understand that you are making objective decisions about the facts and the evidence in the case, and not because you happen to be friends with someone. And so that's difficult. We all kind of have to walk that fine line about our socializing. So I really do miss that a lot. But certainly association functions where we are all able to be together. We have continuing education where we can all be together and still socialize and network. But that's definitely something that I miss.
Well, and certainly I can tell you that in my 10 years of being a judge, I haven't been doing this as long as you have, but I have the same experience that I miss a lot of the camaraderie of the being a practicing lawyer and being in the trenches with people and helping them work through and solving problems.
Yep. Absolutely.
And then just being able to hang out afterwards and talk about stuff. Because as judges, we don't get to talk as we could when we were private lawyers.
That's right.
So, Commissioner, let's talk about what you do up there in Clay County as a family court commissioner. Tell us, in a normal week for you, what kind of cases are you handling and what are you dealing with? What are you seeing?
Sure. So I start the week out with paternity establishment. So what that means is when people are not married in Missouri, in order to assert their custodial rights, to get rights of visitation and parenting time, and then to assess child support obligations, there has to be a judicial proceeding generally in order to establish the fact that they are the parents of the child. When parties are married, there's a presumption in the law that the parties to the marriage are the parents of the child. So I start the day out with paternity establishments. Those are the ones that are brought by the Division of Child Support Enforcement. So in Missouri, the prosecuting attorney's office and the Division of Child Support Enforcement is authorized to bring these types of cases so that they can establish child support obligations for people who have not been married. So that's what I start off with. Then Monday afternoon is criminal child support enforcement. So the prosecuting attorney's office is authorized to file criminal charges, either misdemeanor or felony, against people who are not abiding by their child support obligation. And if they have reached a certain number of months in which they have not paid child support or a certain amount of accumulated arrearage, a criminal case can be filed against them. So I handle those types of cases, both misdemeanors, felonies, and then I could have a trial in one of those cases. A lot of what I do is monitoring people who've been placed on probation. Putting people in jail is certainly authorized by law, but may not be the best way to handle a person who has gotten behind on their child support. Obviously, if people are in jail, they're not paying child supports. What we try to do is really at least give them the opportunity to be successful on an order of probation so that during that period of time, they can work and make their child support payments. So I monitor folks who are on probation to make sure they're doing what they need to do. Then throughout the rest of the week, I handle private paternity establishments. So in other words, same situation, but it's not being brought by the prosecutor. It's being brought by either a mom or a dad who wants to establish legally their rights to children and their obligations with regard to those children. Once judgments of custody and child support are ordered in the state of Missouri, those are always modifiable upon changes of circumstances throughout the course of the time that the children are minors. So I do a lot of modification cases because circumstances change. People's incomes change. Their jobs change. Sometimes they need to move away for work. Sometimes there's circumstances regarding the child and their relationship with the parents. So we need to see about whether or not we need to modify the provisions of those judgments. So I do a lot of that. Can do some dissolutions, but primarily the dissolutions in Clay County are handled by two other family court judges that we have. And then on Thursdays, I do civil contempt child support. These are, again, brought by the prosecuting attorney's office, operating on behalf of the Division of Child Support Enforcement. And sometimes, again, when people are not paying child support that they are required to pay, if the prosecutor decides not to proceed with the more serious charges of criminal charges, they can file what's called a motion for contempt, in which they ask me to hold the person in civil contempt for failing to pay their child support. It's a little bit more flexible. There are more flexible remedies that we can have if we do find them in contempt. And so we have a very, very large and active civil contempt child support docket. And then in the afternoon, we do child support modifications. So again, based on changes of circumstances, child support in a case can be modified upwards, downwards. It can be terminated under the right circumstances. So I hear those types of cases. And then I also then have conferences with counsels, usually on Friday, about upcoming trials. We talk about how there are different ways we might be able to try to have the parties settle those cases rather than having to have a trial. It's a busy week.
It sounds like an extremely busy week. And that's just what I was going to say. It sounds incredibly busy. And with all of those types of cases, and you've been doing this now for a really long time, has the mix changed over the years? Are you seeing more of one thing than another thing now than you used to see, or has it stayed pretty much the same?
That's a great question. I will say that since I began as commissioner, the number of matters that are appropriate for paternity establishments has increased substantially. As I'm sure folks are aware, the number of children these days that are being born to folks who are not married is increasing substantially. When I first started, I was doing dissolutions because there weren't as many paternity establishment type cases, but the number of those have increased so substantially. And that's why two of our other family court judges have now just devoted themselves to the dissolutions and allowed me to then expand those paternity establishment dockets. Lots of kids, 50% and up, are being born now outside of their parents being married. And so not only the number of those have increased, but the complexity of those cases have increased a lot as well. When you're determining custody between two parents who have been married for some period of time, you have the establishment of a relationship between the parents, at least at one time. Obviously now maybe they're not getting along. But in the past, they have cared a lot about each other. They have respected each other. They have trusted each other. And they may have raised children together for many, many years before they get to the point where they feel that they need to end their marriage. And so the dynamic in determining the custody and parenting time situations for those families is drastically different than establishing paternity, custody, and child support for parents who have perhaps had a very, very short relationship. They have not perhaps been together for the period of time it takes to really know someone and trust them and have the communication skills and the commonality of beliefs even that it takes to be successful at co-parenting. So the challenges with those paternity cases are many. You have people who they just don't see eye to eye on much, and they really don't sometimes care for the other person at all, but they did have a child with them. And now I'm in a position of trying to craft a parenting plan for them that's going to allow them to each have frequent, meaningful contact with their children, to assist each other in making determinations about the child's future, health, education, and welfare, those types of decisions, establishing financial obligations between the parties. And that can be really, really difficult in those circumstances sometimes when you've got people who just don't have that basis of a relationship that they might have had they been married previously.
Absolutely. Most people would tell you who have had experience, there's usually a lot of emotions in family law cases, and they're not always the same that they've been throughout the relationship. But because of that, it's always an extra layer of complication.
Absolutely right.
Trying to sort out a solution to handling those things. All these different types of cases that you've talked about that you handle during the week. As a commissioner, do you approach any of these things differently? Do you have the same mindset as you approach each of these types of cases? Or tell our listeners whether it makes any difference to you what type of case you're hearing on a day-to-day basis and whether it changes your approach.
Well, let's put it this way. I try to approach every one of these cases as compassionately and patiently as I can. Now, I am not going to say that I am 100% successful in that because sometimes certain circumstances do try my patience. I am still human. One thing that is frustrating is when parents are arguing to the extent that I can tell that it's really harming their children. That I lose patience with, and it's very frustrating for me. Yes, you're exactly right. There are a lot of emotions that are involved in these cases, and sometimes people let their emotions get the better of them, and they act in ways that they would not be proud to later on say that they acted. I try to understand that people are going through what might be some of the worst things they've ever been through in their lives. Those of us who have children love those children more than anything in the world, and we want what is best for them. And often, obviously, there's a disagreement between parents about what is best for children. And so I try not to judge anybody on what they do on their best day or their worst day. It is extremely stressful for people if we're not even talking about custody, but we're talking about child support. It is extremely stressful for both of those people. The person who may be receiving child support is stressed out about whether or not they're going to have sufficient funds in order to appropriately care for the children. Are they going to have the money to pay the bills? Are they going to have money to send to school with the children for a field trip or to pay for soccer or uniforms? And the person who's responsible for paying child support is also very stressed out. They want to make sure that they are able to financially support their children, but also still be able to support themselves. And maybe they've gone on and they have a second family, and they want to make sure that they have the ability financially to support their second family and their additional children they may have had. So it's definitely far from perfect, but I do try to understand what people are going through and give them the time and the opportunity to communicate effectively to me what their concerns are and for me to take them seriously.
I think that's incredibly well said. And I've always tried to operate on the philosophy that I never see people on their best day. As a trial judge, I had to remind myself of that a lot, that you never see people as a judge on their best day.
It's true.
And so you never want to draw conclusions from it. We know how stressful it is for the people that come in front of us in cases like this. We know how important it is to them. And so we understand.
It's nerve-wracking and scary too, because if you haven't had any involvement with the legal system and the next thing you know, you have a case in front of a commissioner or a judge and you got to come to court, you got to get dressed up, and it's about maybe one of the most important things in your life was your children. That is nerve-wracking. You just stressed out, and it's just scary. It is really scary.
Yeah.
One thing I just will throw out there too, when we're talking about litigating in family law matters is, I have said that litigating a family law matter is the worst way to resolve family law matters, except that's the hand that we're dealt. I encourage people as much as I can to resolve their cases, and I become as active in those cases in talking with the attorneys as I can be in trying to assist them in resolving them. There have been studies that have shown that if parties resolve the matters themselves, they are much, much more satisfied with the result than if they litigated it. And they feel that they have had an active part in the resolution. They feel ownership of that. They're less likely to come back to court, or at least to come back to court as soon if they have had control over the outcome in their last round of litigation. Those outcomes are more long lasting. In other words, if they've reached those resolutions themselves. I am a huge proponent of mediation. And that's another trend that I have seen really change over the 20 years, or, even since back when I was in practice. It was rare that parties would attend mediation in a family law case prior to coming to court. Now it's the rarity of parties don't. And at least here in Clay County, we require in almost every case that the parties, at least in family law matters, attempt mediation. And we are fortunate enough to have some really, really great mediators in our circuit. And we even are very fortunate to have resources to do low or no cost mediation for folks who cannot afford to pay a private mediator. And we have utilized that to the extent that we are able to settle most of our family court cases. And so that's really what we're aiming for, is that the parties have some self-determination about the outcome. And so that, you're not inviting me, who is a stranger, who has never met your children, who has no idea what their lives are really like, to make a decision, again, maybe one of the most important decisions involving this family after 3, 4, 5, 6 hours of evidence. That'd be pretty scary if I was a litigant and I was leaving it up to someone that I don't know and who doesn't know my family to determine how my family is going to operate for the next period of time. It's very scary.
Absolutely. And I couldn't agree with you more that in my experience as a judge, that parties that resolve the cases that can agree to a resolution, even if it isn't 100% what they want, they tend to be much happier with the outcome.
Absolutely.
And there's a lot less animosity going forward. And it helps to also kind of repair relationships.
Absolutely.
And it keeps it from getting so adversarial and confrontational.
Well, the mediation, I think, is more than just being about reaching a settlement even. The mediators are so well trained and they are so good that they incorporate communication strategies and conflict resolution tools. And they are teaching the parties about how to do that themselves moving forward. So I think that, again, the mediator is important to reach a resolution, but at the same time, they're showing the types of skills and the manners in which you can reframe arguments and communicate in an effective, caring, non-accusatory manner with your co-parent so that you can resolve some of these things yourselves in the future. And I think, in fact, some of these parents and parties have had such good outcomes in mediation. If something does change in their life moving forward, they are more apt to go back to mediation to try that first before they file their lawsuit next time. And that's fantastic. It's fantastic for them, but it's also fantastic for the judicial system because, as you said, we're so busy and we're just trying to get everything done and get to everyone in a timely manner. And if folks are able to resolve those things without even having to come to court, then that gives everyone who does have to come to court a better opportunity to be heard sooner.
Absolutely. And that's a wonderful transition into what I wanted to ask you about next. You mentioned that in the 20 years that you've been a commissioner, you've seen this growth in mediation. What are some of the other changes that you've seen in your 20 years of being a commissioner in the family law area? What procedures or types of cases or tools that are used in court? I mean, you've seen a lot of change, I'm sure, over the years. What do you think the biggest changes are in how family law cases are handled today?
I'd say I can think of two things specifically, but the first thing I think is the move toward legitimate, meaningful co-parenting. When I first started practicing, and this was in the early 90s, you're going to have what we used to call primary parent, and many, many times it's going to be the mom. And it was rare at that time that a dad might get the children to primarily be living with them. They were relegated to basically every other weekend visitation with their children. It was just the norm. I mean, that was it. over the past 35-ish years, that has really, really evolved to a point where now the presumption, as you well know, in the statute is that the parties will have substantially equal parenting time. And it's only under the circumstances of that family that can rebut that presumption to do something different. I mean, that's a vast, vast evolution in how we handle children when their parents are not together. And also, I think it's much more common now that moms and dads both have an equal footing when it comes to court as far as whether or not one or the other of them is going to be designated maybe as this child's residence for education and mailing purposes. Everybody's coming in here now, I think, on an even keel. Now, obviously, evidence in that particular case can sway that one way or the other. And that's been very positive as far as I'm concerned with children and their ability to maintain their relationships with both of their parents, and that they're not just seeing their dad, 4 days a month. That's really important. Another change that's, I think, happened is that we've evolved a little bit in the child support, as well as we're recognizing that, again, along with this shared parenting comes shared financial responsibility. And so now we're calculating child support, giving credit to both parents for the periods of time that they are spending with the children, so that it's not just one parent presuming to buy everything for the child and the other parent just has to pay for whatever out of what little money they have left. We now expect both of them to provide adequate financially for the children when they have the children with them, and we give them credit for that towards their child support obligation. The other trend that I'm seeing now, in particularly, I'm going to say this is maybe over the last 10 years or so, is third-party custody. And what that means for those who are listening is giving custody of a child or children to someone other than their parents. There's been a big evolution in the law in the last 10 or so years in which parties who are not their parents can come in and, under proper circumstances, convince a court to provide them actually with the custody of the children. It's not only if the parents are for some reason unfit or unwilling at that time to raise those children themselves, but it can even be for special circumstances in which the welfare of that child would be best served by being in the custody of a third party. There's been a lot of evolution in the law about this. It used to be, if you're going to do something like that, you go to the probate court and you're going to get guardianship, right? There are some legal strategic advantages to doing it as a third-party custody case versus the probate route now. And I think lawyers are catching on to that. I'm just seeing a lot more of the third-party custody cases than I've ever have in the past.
That's really interesting. And certainly you're right. That's an evolving area of the law, and it's going to be fascinating to kind of keep an eye on where that goes in
Absolutely.
the next 10 or
Very
15
much
years.
So. Yep.
One of the things that I had noticed as a trial judge before I became an appellate judge was that is particularly in family law type cases, there seemed to be a rise in pro se litigants who are coming to court without attorneys.
Absolutely.
Have you seen an increase in people who are coming to family law cases and representing themselves? Has there been an evolution in the tools available to them to help them do those things?
That's a great point. Yes, absolutely, 100%. I don't know the numbers, but the number of pro se litigants, especially in family law, which is what I'm familiar with, have increased substantially. I think that there's a couple reasons for that. I think, first of all, look, lawyers are expensive. And we've been through some economic times here in the United States where people just do not have the resources available to them to hire attorneys. And I completely understand that. And it's very difficult. The other part of that, and I think probably as a secondary offshoot from that concern, is that we are providing them now as a judiciary, I think, and as the court system, with more tools in which they can hope to be successful in that. We have pro se forms that folks can find on the internet. I would highly encourage anybody listening, utilize the forms that have been approved by the Supreme Court and by the judiciary in Missouri. Do not use forms from other states. Do not use random forms that you just find on there, because they may not be correct and they may do you more harm than good. So if you're going to try to represent yourself, first of all, look for those Missouri forms. Now, those forms don't cover every circumstance, and so you may not find one that meets your needs, but at least that's a good place to start. And we have, for example, one of the associate circuit judges here who does a lot of family law. He has a very specific docket for folks who want to get a dissolution and they are representing themselves. And so we're able to assist them with certain resources and just operate within that realm just for those folks on that docket. look, if anybody can possibly afford an attorney, they really should get an attorney. These are complicated, important, difficult types of cases, and the preparation of paperwork can be very daunting. So I think I would tread cautiously, but I do appreciate the fact that there are court provided resources for people who find themselves in that position, that's the only way they have to try to move forward.
I think that's a wonderful way to put that, because certainly of all the various types of cases, family law is one of the most paperwork intensive
Absolutely.
that you can get into. And that makes it even more challenging for pro se folks.
Yeah.
And so I would tell anybody who is thinking about trying to handle one of these matters on their own, if there is any possible way that you can find the resources to hire an attorney, you should do it.
Yeah, 100%.
My experience shows me and tells me that you will be much happier down the road if you take that short-term pain of finding those resources to get proper legal representation. But we recognize that that isn't always possible. And if you don't have other options, we are at least now making tools available to assist you to try to help. Now, the tools are made available and our clerks can't give you legal advice. The court can't tell you what to do. I always tell litigants, I'm the umpire. I call the balls and the strikes. I can't tell you what pitches to throw. But there's only so much that we can do to help you with those forms, but they are there if you absolutely have to have them.
And they're being improved all the time. The committees that are responsible for developing these forms, they're excellent about taking feedback from the public and from judges and commissioners about what could be improved. And they're constantly reworking those to make them either more user-friendly or more appropriate. And so that's much appreciated also.
Absolutely. And I wanted to talk to you a little bit about, as we transition to a program that I wasn't familiar with, which is your parenting court program. This is something I didn't know anything about, and I know something that you've had a huge hand in getting off the ground. Explain a little bit about how that program got started and how it works.
Yes. Now, you're going to probably have to cut me off because when I start talking about parenting court, I sometimes can get carried away. Bottom line, what our parenting court is a diversion-ish program for folks who have found themselves in the situation that they've gotten behind on their child support, and where the prosecuting attorney's office has filed either a criminal or a civil contempt matter against them in order to try to enforce their child support. So we encourage folks who are in either situation, civil or criminal, engage with parenting court. We developed this in 2016, 17. At the time, now Circuit Judge Alicia O'Hara was a criminal prosecuting attorney handling child support cases. And we were of the same mind, which is the tools we have to encourage and motivate folks to pay their child support are very limited. The way I describe it is the tools that we have really generally under the law, they're all a hammer. And when you have a hammer, that's all you can do is just hammer those nails, right? And so we wanted to try to develop other tools that we could use that would be appropriate to the type of case that we were presented with. And so obviously incarceration is the most severe penalty that we're authorized to engage in for child support. But as we mentioned earlier, that's not going to get the child support paid. Okay. So what we'd prefer is to just put people in a position where they could be successful in paying their child support. Along with that, we were very interested in also putting people in a position where they could get back to engaging with their children if they haven't been, because sometimes when people are behind on child support, they feel cautious about reaching out to have relationships with their children. Sometimes in those situations, the parents have really lost any commonality. They are really not co-parenting because of resentment and anger about the circumstances regarding the child support. And we really wanted to try to help reunite some of those families. So she and I worked together and we developed the parenting court. So what we do is we invite people. There's a screening process. Only certain people are eligible. And basically that's around what their other criminal background might be or whether there's domestic violence in the situation. Those people would be excluded from eligibility. But generally, most folks are eligible for the parenting court program. And what we do is we ask them to undertake a 1 year, a 12-month program with us. During that period of time, we work intensively with you. And we will give you a holistic approach to your situation. And Judge O'Hara, when we first started this program, was very, very integral in reaching out to community resources, because at that point, we didn't have any money to run this program. We were just going to do it on what we had. And so we needed to engage with and contract with community resources who could provide those resources to us at no cost. Because one thing we definitely did not want to do would be to charge these people to be in the program, because what we want them to spend every dime they have possible to pay their child support. So anyway, we've got mental health resources. We have substance abuse resources. We have job training and employment resources for folks. We have mediators that we can send them to. We are very, very fortunate to have right now an attorney that we can ask to represent them on associated issues. And she's willing at this point to do that for no cost whatsoever. So again, if it's re-engaging with your children, doing a motion to modify, something like that, to try to establish or reestablish parenting time and visitation. So we will give you those resources for 12 months while you're in the program. But we also ask you to take a financial literacy class while you're in this, just so we can make sure you're up on your budgeting and etc. And then we ask you to do an 18-hour parenting education class. And that is geared toward communication, tools for collaboration, co-parenting, in the hopes of reestablishing those relationships. That's kind of all the sticks associated with the program. But here are the carrots. Instead of being placed, for example, in a felony child support case on probation for 5 years, which is the general go-to resolution in a felony child support case, and being on probation for 60 months, you can be on probation for 1 year. If you successfully complete the parenting court program, you will be permitted to withdraw your guilty plea, and the prosecuting attorney's office will dismiss the charges. So you have no record that that felony was ever filed against you, nor that you pled guilty to it. In a civil contempt action, once a judgment of contempt is entered, at least in Clay County, we monitor those folks on a monthly basis for the entirety until their arrearage is paid down. So, I mean, I'm telling you, that can be your life, okay? Depending on how far you might be behind.
That could be a really, really long time, yeah.
That were coming to see me on child support contempt the first day I showed up here as a commissioner, and they're still coming. Okay. So it's a huge time commitment. If you enter parenting court, and if you successfully complete parenting court, 1 year. And at the end of that year, if you successfully complete parenting court, the judgment of contempt against you will be set aside, and you'll be given a fresh lease on life to just begin and continue paying your child support. And if you do so, we're going to leave you alone. So I'm not going to quote you all the statistics, but just let me tell you that our measures of success for this are some subjective and some objective. The objective ones are that at this point, anyway, 100% of our participants are paying something towards child support every month, which is way different than the population at large of those people who owe child support. That's somewhere statewide around 30%, and we're at 100%. A large portion of these folks are paying not only their current every month now, but they're paying an amount extra to pay down their arrearage. We've had people who've been able to pay off their arrearage while they're in parenting court and just go on in the future then with a zero balance and just start from fresh. But beyond that, and beyond like the numbers, which we're also, of course, very proud of, we've had people be able to reestablish relationships with their co-parent, with their children. We have folks now who are going to ball games that they weren't permitted to go to before and watching their kids play sports. A participant who was invited into his daughter's marriage. He had been out of communication with her for years. They were able to reconnect because he was so encouraged by the fact that he could go to her with a clean conscience, that he was doing the right thing and that he had completed this program, that he was able to reach out to her, and she was kind enough to reach back, and they reconnected, and he was able to attend her marriage. Just things like that just warm our hearts. And you can't put that into numbers. You can't, necessarily objectify that. But my goodness, that's that's why we do what we do, is to try to get families in better positions than they were to start with. And so really proud of the program. We've had the opportunity to travel around the state and in fact around the country and even to Canada in the past to give presentations about parenting court and what we're doing, and try to encourage more courts to look into these non-traditional methods of enforcing child support. We also have really good recidivism rates. So in other words, once people graduate from the parenting court program, they don't just drop off. They continue to do what they're supposed to do about child support. And the very, very few of them have had to be referred back for additional enforcement measures. So we consider it to be quite a success. And honestly, we have court once a month. It's my favorite day of the month because we come, we have a team meeting, we talk about each person, how they're doing, their hurdles, their encouraging news. And we have a case manager that works with each one of them, and they share their encouraging news news with her and she shares it with us. And then we're able to congratulate them when they graduate, give them a certificate, shake hands with them, give them a hug, and send them on their way. So thank you for asking, because I'm happy to talk about that to anyone, even a signpost. I will tell them about parenting court.
Well, you should be proud of it. It's an incredible program, and what a great partnership between the courts and the community to pull all of that together.
Well, and I will also just say that we did start on a shoestring. We have been so fortunate since that time that the Office of State Courts Administrator has grants available to circuits to start these types of programs. We've been able to have some the benefit of some grant money that has helped us grow the program. And I would encourage anyone who's listening, who's part of a court to reach out to OSCA and ask them about those types of resources. Because if you have any inkling at all that you'd like to start one of these innovative programs, they will help you. And there are grant resources available for those startups. So please reach out for that too.
Absolutely. And I would encourage anybody who works in the judicial system who might be listening to this, who thinks they have a good idea about how we could be doing things better, please don't hesitate to speak up. We will find ways. We will take good ideas and make them happen.
Absolutely. It's just really interesting, some of the creative things that different courts are doing. It's just, I think, in fact, we're going to try to have a presentation at our next judicial college about, or maybe the one after that, about a lot of the programs that folks are doing, because I just don't think everybody knows that that's even available. And that, look, I think in this day and age, we really need to start thinking outside the box. Like I said, coming to court on your family law matter is the worst way to deal with it. If we can find ways to help people outside of just litigating things, and especially in family court, I think we're going to help people so much more than just coming in here, putting the evidence on, bringing the hammer down, and live with it. I just think now is the time to really think outside the box.
I completely agree. And I love that it's your favorite day of the month. I know, based on my experiences as judges, people may not know, we don't get a lot of happy days in court. Yeah. There are only a few things where everybody leaves the courtroom and they're all happy and excited. One is adoptions.
Adoptions, yes.
Adoptions are great. One of the few happy days you ever get as a judge.
That's right.
And then those days when you have people who successfully complete programs like this and have really turned a corner, they're incredible days as a judge. And I'm so
absolutely
excited that you get to have those.
Yeah, thank you.
Now, kind of on the flip side of that coin is when you have a family law matter that we don't like to see them get litigated. We prefer to see them get resolved, but sometimes they have to be litigated. And there are undoubtedly some of the most emotional cases that we handle as judges. When you're handling a family law case, when you have something that is contentious on both sides when it goes to trial, you as the commissioner, you're going to have to pick a winner.
Yep.
And at some point, that decision is most likely going to make one side happy and it's going to make one side mad. Yep. Knowing that going in, how do you balance that? I mean, what can you do to make sure that even though you're going to disappoint somebody with the decision that you make, how can you make them feel that they have gotten a fair shake, even if they're not going to be successful?
Yeah, that's a great question. And that's something that we all struggle with. I think probably the most important thing we can do is making sure that they feel that they have been heard. I think that giving everyone an opportunity to fairly and adequately present all of the evidence that is relevant to the issues that we have to decide is giving them the benefit of that. And again, we all have crowded dockets. That's not always the easiest thing to do either, but to give people time and space to present their case and to listen intently and engage with the process so that they know that we are listening and we're considering everything they say. We're taking it very seriously, that it's earnest, and we understand that. I think also if certain rulings are made, if it's possible, it's not always, but sometimes if it's possible to make the ruling and then explain the ruling as much as possible. As you know, as family court judges and commissioners, there are a lot of findings that we are required to make when we issue our judgments. And I think that's really helpful for people. Again, they may not agree with our findings, but at least they will know that we have listened to the evidence. We've applied it to the law that we're required to apply to that case. And here are the findings that we have made. It is a very, very detailed process that we have to go to make these decisions, and that's reflected in our judgments and our rulings. We've talked about this several times today, which is let's try to resolve this without a trial. And if I feel like I have given everyone the opportunity to do that, sending them to mediation, meeting with the attorneys in pretrial conferences, witnesses, giving them an indication of maybe what my thoughts might be if the evidence comes in as they've described it to me in a conference, doing temporary orders along the way to see how those are working out, being engaged in the process. Look, these are not our children, but we need to make sure the litigants understand that we know that it's their children and that we take that very seriously. And we're not just up here flipping a coin about what's going to happen. I just think the openness to explaining what we're doing and why we're doing it probably goes a long way. And just treating people with respect. Again, as you said, you're seeing them on possibly their worst day, but definitely not their best day. But nonetheless, we treat them with respect and allow them to be heard. And at that point, if they feel that after all these opportunities we've given them in order to resolve the case without litigation, if they decide that they do want to proceed with litigation, then that's okay. As long as they understand that they may or may not, as you said, agree with the outcome, then I feel okay about it.
Very good. And I very much appreciate that answer. Last couple of things I want to ask you here before we let you go. We've taken up a lot of your time today, and
I've
sorry
enjoyed
for
this
that.
immensely. Thank you.
Any advice that you want to offer to anybody that has a family law case or may have a case coming up that they want to deal with? Any advice that you want to offer them that might make them more comfortable in the process or that might more effectively help them present their case to the court and make the court's job easier?
That's a great question. We've already talked about this, but the first thing I think they ought to do is, if at all possible, get an attorney. Attorneys, I describe this to folks all the time. You know, it's hard to be an attorney. You have to go to a lot of schooling and it takes a long time to become proficient at it. I tell folks this, the court is required to apply the same rules to everybody, whether you've been to law school or whether you haven't. I can't bend the rules or I can't help you if you are representing yourself. I can't tell you how to present evidence. I can't tell you how to file your paperwork. So get an attorney if you can. Secondly, if you're involved in a case which involves children, please keep that in the forefront of your mind, is that what we're here to do and what our obligation is to determine what's in the children's best interest. And we hope that as parents, that's also at the forefront of your mind. Please do not allow your animosity or your emotion with respect to maybe the state of your relationship with the other parent or with the other circumstances that you're in with the other parent cloud the shining star that it needs to be presented, which is what's in the best interest of your child. Just do not allow that animosity to cloud that, because when we see that, that's really sad. And what we say around here, and I'm sure this is not unique to us, is love your children more than you hate your ex. Focus on your children. And when you're doing that, the courts can see that. The courts can understand. Here's just some really basic stuff. Dress appropriately. You're going to be much more successful in court if you don't show up with a tank top and cut off shorts. I know different courts across the state have different rules about this. I'm pretty strict about that. I think court is extremely serious, and I think what you're doing there is really important. So I expect people to dress like it's important. And, you know, I don't expect everyone to wear a three-piece suit, but I do expect people to wear long pants and dress appropriately for court. And then just show respect to everybody in the courtroom, not just the judge or commissioner, but the other litigants, the other attorneys, the deputies, the clerks. They're all there to try to help you, and showing appreciation and respect for that, that also goes a long way.
I think those are all excellent tips, and certainly tips that I have seen be successful from both as a private attorney and both as being a family law judge for a period of time. You know, the one thing to boil everything down, particularly when you're dealing about child custody type cases, I always tried to tell people, and it's much along the same lines of what you've said, but don't convince yourself that what's best for you is best for your kids.
Exactly. Exactly.
So many parents that come in, they just believe that what is best for them is also what's best for their children. And
Right.
if you're looking at it objectively, that isn't always true. Sometimes it's true,
Sure.
but sometimes it isn't. And I think convincing people and getting them to understand that their best interest is a separate question from what is their children's best interest. It's a hard thing to do as a parent because you're so aligned with them,
of course,
with your children,
sure.
which I totally understand. But
yes.
Those are excellent things for people to be thinking about, and I think a wonderful place to leave our discussion about family law today. Commissioner Roberts, thank you so much for being here today. I do want to ask you one question. I ask everybody this. It's just a quirk of mine.
Okay.
So what is your favorite thing that you have seen lately? It can be a TV show, a movie, or a pretty sunset, or just anything. What have you seen lately that you really like?
There's a lot to choose from. I'm a very blessed person. And so narrowing that down is hard. But here's what I'm going to tell you. It's almost Easter when we're recording this. So last year, I got some new chickens. I have chickens at home and they have started laying. And they are laying the most gorgeous blue and green eggs. And it just reminds me of Easter. And so every time I go out to the chicken coop after work, I'm decompressing in my yard and I'm watching the chickens cluck around, and I go in there and I grab those eggs, and they are just more beautiful than anything I've ever seen. And you couldn't dye them that perfect color. So I'm going to say chicken eggs.
I love it. That's a great answer, and certainly not one I've had before.
Oh, that's the first? Okay.
That's the first.
Great.
You're the
like
first chicken
unique.
egg.
Okay, good. Okay, fair enough.
Commissioner Roberts, thank you again so much for being here today. Thank you for teaching me about family law. And
well, thank you so much for having me. I really enjoyed this, and I really enjoy this project. I'm really glad you're doing this, and I'm going to be an avid listener.
Awesome. That is so good to hear. I appreciate all your years of service to Clay County. And again, thank you for being here today. I want to thank everybody who's listening and watching us today, who's hung with us. I hope you've learned something, and I hope you got some enjoyment out of this, and it gave you a new insight into how these cases are processed. If you've enjoyed the podcast, don't forget to like and subscribe to us on all of your platforms of choice, Apple, Spotify, YouTube. We'd be happy to hear from you. Drop a comment. Let us know how we're doing if you're enjoying it. We'd love to talk to you about those things. I want to again thank Commissioner Roberts for being here today. With nothing else for you today, this podcast is adjourned. Thank you, folks.